Lincolnshire, 1279. The church is empty, except for him. Outside, a village tries to sleep. A man is dead somewhere nearby. You don't need to know where yet. The man at the altar knows exactly what he has done. He is not afraid. He has done this before. He adjusts his position against the stone. His knees ache. His hands are wet. In a few hours, when dawn comes, a royal official will arrive at the church door, a man called the coroner, and this fugitive will say certain words in a certain order, and those words will be more powerful than any sword, any judge, any prison wall in medieval England. He will confess, openly, completely, and then he will walk free. What you're about to witness is not a miracle. It's not mercy. It is something far stranger. A man who found the hidden grammar of the law and used it 4 times across 35 years in one of the most audacious long cons in English legal history. The world, how the system worked. To understand what this man did, you need to understand the machine he was exploiting. In 13th century England, a person accused of a serious crime, robbery, assault, homicide, had one option outside the courtroom, the sanctuary. Run to a church, touch the door, cross the threshold. You were, at that moment, under the protection of God. And in medieval England, that was not a metaphor. It was law. The crown could not enter. The village could not drag you out. You had 40 days. 40 days in which to make a decision. If you surrendered to trial and were convicted, you hanged. But there was another option, one that the church and the crown had negotiated into existence over centuries. You could confess your crime to the coroner, the royal official who arrived at the church door, and you could swear an oath to leave England forever. This was the abjuration of the realm. The ritual was precise. The abjurer was given a wooden staff, a symbol of the pilgrim, the traveller, the man without a home. He was assigned a specific port, Dover, Southampton, Bristol, depending on where in England he stood. He was instructed to walk that road without deviation, without stopping, wearing a white tunic, carrying nothing of value. He was to take ship at the first available vessel and never return. If he left the road, he could be killed on sight. If he was found in England after his crossing, he was an outlaw, outside the law's protection entirely, and any man could lawfully cut him down. The system was elegant, morale even, and it had one catastrophic flaw. There was no central register. When a man abjured at a church in Lincolnshire, the coroner recorded it in his rolls. That document stayed in Lincolnshire. There was no mechanism, none whatsoever, to transmit that information to the coroner in Yorkshire or Kent or Devon. There were no photographs, no fingerprints, no national database of faces. There was not even a consistent standard for recording a man's name. The same person might appear in different records as William, Wilhelmus, Guilielmus, or simply Lared, meaning the red, a reference to hair colour so common in medieval England that it described perhaps 1 man in 10. The system assumed that abjurors left. It was built on that assumption. It worked, most of the time, because most people believed it would work. But belief is not infrastructure. And one man knew the difference. The 4 escapes, the Lincolnshire coroner's rolls, are not dramatic documents. They are administrative records, terse, practical, written in abbreviated Latin, concerned above all with procedure. But sometimes, in the margins of bureaucracy, a person emerges. The first record is from 1272. A man, described as Wilhelmus Lared, seeks sanctuary after a killing near Sleaford. The entry is brief. He confessed to the coroner. He swore the oath. He was assigned the port of Boston, on the Lincolnshire coast. He was given his staff. He walked to the port, and then nothing. No record of departure. No ship's manifest. In an era before passport control, this means precisely what you think it means. The second occurrence is 1279, 7 years later. A man described in the rolls as Wilhelmus Rufus, William the Red, in Latin this time, seeks sanctuary in a church near Lincoln after an assault that left another man gravely injured. He confesses. He swears. He is assigned Boston again. Is this the same man? The coroner in 1279 has no way to know. He has no document from 1272. He has no description beyond hair colour. And red hair is not a rare thing in this county. The name is similar, but names in medieval England were not standardised. Rufus and Lared mean the same thing in different languages. It could be coincidence. By the third occurrence, 1285, a robbery on the road between Grantham and Stamford, coincidence becomes a pattern. This time, the name in the rolls is Wilhelmus Reader. No article. The same man, almost certainly. But almost certainly is not a legal instrument. And the coroner of 1285 is not looking for patterns. He is filling in a form. The fourth occurrence is 1307, 35 years after the first record. The crime is not specified precisely in the surviving roll. The entry is damaged. But the sanctuary is sought, the oath is sworn, and the name given to the coroner is a variation of the same two words that appear in 1272, in 1279, in 1285. 4 times, 4 confessions, 4 oaths, 4 times assigned a port. And now, here is the thing that changes everything. Secret fact, place this at peak tension. The abjuration of the realm was not designed for men like this. It was not designed for criminals at all, not in its origins. The mechanism emerged from a much older tradition, the protection of the innocent. A man falsely accused of a killing, pursued by the victim's kin before any trial could be held, had a right to sanctuary. The church insisted on it. The oath to leave England was, in its original form, a form of mercy for the wrongly accused, a way to de-escalate vengeance cycles that could consume entire villages. William Lared did not discover a loophole. He inverted the soul of the law. He took a mechanism built to protect innocence and used it 4 times as a shield for guilt. What he understood, with a clarity that no legal scholar of the period articulates quite so plainly, is that the abjuration system was, at its root, a trust mechanism. It worked because the officials who administered it trusted that the men standing before them were telling the truth about their intention to leave. It worked because there was no way to check. The absence of centralized records was not a flaw someone had overlooked. It was simply the nature of a state that had not yet invented the administrative technology to track individual movement across county lines. He was not exploiting a gap in the law. He was exploiting a gap in the state. Resolution. The silence of the record after 1307, William Lared, or Wilhelmus Rufus, or Wilhelmus Reader, or whatever name he was using by then, disappears from the historical record. We do not know if he was caught. The surviving coroner's rolls of Lincolnshire record no execution connected to any name in this cluster. There is no entry in the patent rolls, the records of royal pardons and judicial proceedings, that clearly corresponds to him. He is not in the jail delivery records. He is not in the heir proceedings of the period. He simply stops appearing. There are several explanations, and a responsible account must hold all of them simultaneously. He may have finally left England. actually sailed this time for France or Flanders, and lived out his remaining years beyond the reach of English record-keeping. He may have died of age, of illness, of violence, in a place or manner that generated no surviving document. He may have changed his name so thoroughly that he exists in the rolls under an identity we cannot connect to the man in 1272. The records that might answer the question may simply not have survived. Medieval administrative documents are fragmentary by nature, victims of fire, flood, and 7 centuries of archival accident. Or, and this is not melodrama, this is a genuine possibility. The system simply never caught him. He lived and aged and died, having confessed 4 crimes to royal officials and walked free 4 times in a country that had no mechanism to stop him. We don't know. The honest answer is, we don't know. And that is the most important sentence a historian can sometimes say. Mind blow. And then, the teaser. We like to tell ourselves that the medieval world was simple, that modernity invented complexity, databases, bureaucracy, systems of surveillance and verification that would have made William Lared impossible. But consider this. In 2011, a man named Baljinder Singh was deported from the United Kingdom and re-entered under a different name 7 months later. The Home Office's databases did not flag him. In the United States, criminal records are maintained at the state level. A conviction in Texas does not automatically appear in a background check conducted by an employer in Maine. A person expelled from one jurisdiction may find a clean record waiting for them in the next. Extradition between countries requires bilateral treaties, political will, and a paper trail robust enough to satisfy 2 separate legal systems. The problem William Lared exploited is not medieval. It is not even old. It is structural. It is the problem of any system of accountability that relies on the free flow of information between independent administrative units, and those units not sharing a language, a format, or an incentive to cooperate. What he found in the stone nave of a Lincolnshire church was not a crack in the law. He found the eternal gap between what a system is designed to do and what it is actually capable of doing. The sanctuary is gone. The wooden staff is gone. The oath before the coroner is gone. But the gap remains. Leave your thoughts on this in the comments. Subscribe and turn on notifications, and see you in the next video.